You know, we spend a massive amount of our lives worrying about the system. It's this giant, faceless machine, the government, the bureaucracy. And I think for most of us, the feeling is that if that machine decides to roll over you, well, you're just flattened.
Right. You're a bug on the windshield of the state. It is a valid fear.
Yeah.
I mean, we're talking about an entity that has the power to tax you, to detain you, to regulate pretty much everything.
Exactly. That is Goliath. But what if I told you that you actually have a sling? And I don't just mean protesting or, waiting 5 years to vote someone out. I mean a specific legal weapon,
Uh-huh.
a tool designed to let you walk into the highest court in the land and force that machine to stop or back up or explain itself.
It sounds dramatic when you put it that way, but you're not wrong.
Yeah.
That is literally the function of the framework we are looking at today.
Sure.
We are analyzing the concept of writs.
Writs, it sounds so old, almost medieval. We've got a stack of handwritten legal notes here, basically a cheat sheet on administrative law and the Constitution of India.
Yeah.
And our mission today is to decode these things, figure out how these tools actually work. Because on paper, they look like magic spells. You've got mandamus, certiorari, quo warranto.
They do sound like spells, but in the legal world, they're just practical commands. A writ is a formal written order from a court, specifically the Supreme Court, or a high court, commanding a party to do something or to stop doing something.
So it's the emergency brake for the state.
It's the braking mechanism, exactly.
Okay, so let's get into the mechanics. The notes here highlight two articles right away, Article 32 and Article 226. Now, my first thought is, well, the Supreme Court is the ultimate power, right? Top of the food chain.
In terms of hierarchy and finality, yes. But here's the first major insight from the source material, and it's one that trips up a lot of people.
Okay.
Article 32 lets you move the Supreme Court. The notes call it the protector and guarantor of our fundamental rights. In fact, Article 32 is so important, it is itself a fundamental right.
Wait, hold on. Unpack that. I have a fundamental right to defend my other fundamental rights.
Precisely. The logic is that a right is meaningless if you have no mechanism to enforce it. So the Constitution guarantees you can go straight to the top. The Supreme Court can't just say, sorry, we're too busy.
That's incredible access. But then you look at Article 226 for the high courts one level down. And the notes say something that feels completely backwards. They say the high court's power to issue writs is actually wider than the Supreme Court's. How is that possible?
It does feel counterintuitive, doesn't it? You'd think the highest court would have the broadest power.
Right. How can the lower court have a bigger toolkit?
It comes down to the very specific wording. Article 32 is strictly and only for the enforcement of fundamental rights. That's its lane.
So if your problem isn't a fundamental rights violation, you can't use that emergency line to the Supreme Court.
You can't. So they're like the specialist surgeon. They only operate on the heart, on the most critical constitutional issues.
Okay, I get that analogy.
Now, look at Article 226. The High Court can issue writs for fundamental rights, and this is the key phrase from the notes, for any other legal right or duty.
Any other legal right. Wow, that's a massive door.
It's huge. It means the High Court is like a general practitioner. They can treat the critical heart condition, but they can also fix the broken leg, the flu, the headache.
So they can handle day-to-day government overreach that isn't, a full-blown constitutional crisis.
Exactly. So while the Supreme Court is the guarantor, you could say the High Court is the broader, more accessible fixer.
That's a fascinating distinction. But okay, before we get too excited about our legal superpowers, the notes drop a bit of a reality check. There's a mention here of Article 359.
Right. Even superpowers have an off switch.
Yeah.
Article 359 allows the president to suspend the right to go to court for your fundamental rights during a national emergency.
So the Constitution gives you the shield, but it also reserves the right to take it away if the state's survival is at risk.
Exactly. It's a sobering thought to keep in the back of our minds. These rights are robust, but they're not absolute in all circumstances.
Okay, let's open up the arsenal then. The notes break this down into 5 specific writs. Let's tackle them one by one. First up is mandamus.
The command.
Yeah, the literal translation is we command. That is a serious power move.
It is. Mandamus is the ultimate tool for fighting bureaucratic inaction. It's an order to a public authority who has a mandatory duty to do something, but just isn't.
So this is for when I go to the license office, I've got all my paperwork, I've paid the fees, and the officer just refuses to process it.
That's the classic example, yes. It compels activity.
Yeah.
But the notes are very clear about the conditions.
Right.
You can't just demand it because the line is long.
Yeah.
First, there has to be a clear public duty. It can't be a private favor. Second, you, the petitioner, have to have a strict legal right to demand it.
And there's a procedural hurdle here, too. It says demand and refusal.
Crucial. You have to prove you tried the normal way first. You formally asked the authority to do their job, and they refused, either by saying no or just by, complete silence.
You can't just ambush them with a lawsuit.
You have to give them a chance to do the right thing.
The notes have a couple of cases here that really clarify this. The success story is sales tax officer versus Khan Hayal.
A classic. In that case, the authority collected a sales tax that, it turned out, was illegal. The law didn't actually allow them to take that money.
So the petitioner went to court.
And the Supreme Court issued a writ of mandamus. It wasn't a suggestion. It was, you have a public duty to follow the law. You broke it. Your duty is now to return the money. We command you to do it.
Simple. You took it. It wasn't yours. Give it back. But then there's this other case, State of NP versus Mandawara, where it failed. And this distinction seems tricky.
It's a subtle but vital one. In Mandawara, government employees wanted the court to force the state to grant them a dearness allowance, a cost of living adjustment.
Which sounds reasonable, so why no mandamus?
Because of the difference between a mandatory duty and a discretionary power. The law said the government may grant the allowance. It was their choice.
It wasn't an automatic obligation.
Exactly. Mandamus can force you to do your job, but it can't decide how you do your job if the law gives you options. The court can't become the administrator.
That prevents the judges from basically running the government from the bench.
Correct. And there's one more ethical trapdoor mentioned, the idea of clean hands.
Suppression of material facts.
Right. If you go to the court asking for this special help, but you lie in your petition, or you hide a key fact, the court will just throw your request out.
I like that. You can't ask for justice if you're not being just yourself. Okay, let's shift gears. Mandamus makes things start. The next two are about making things stop. The notes group prohibition and certiorari together.
Think of them as siblings. They're aimed at the same target lower courts or tribunals, but they operate on a different timeline.
Okay, so let's start with prohibition. To prohibit.
Simple as it sounds. It's issued to prevent an inferior court from exceeding its jurisdiction. The key is, it's issued during the proceedings.
So the trial is happening, the judge is going rogue, and the higher court steps in and just says, freeze.
Stop right there. It commands inactivity. But again, the notes have a fascinating case that shows its limits. TTD Devastanum versus Talapaka.
I was reading this one, the backstory is wild. It involves the huge Tirupati temple authority and goes back to the 15th century.
It does. A king granted these Inam lands, gift lands to a family, but with a condition. They had to provide flowers and tulasi leaves for the daily rituals.
Fast forward a few hundred years, the descendants stop providing the flowers but want to keep the land. The temple authority starts an inquiry to take it back.
And the family tries to use a writ of prohibition to stop the inquiry before it even finishes.
But the court said no.
The Supreme Court said no. You can't use prohibition to stifle a lawful inquiry. It's not a get-out-of-jail-free card. It's a stay-in-your-lane card.
Okay, so what if the court doesn't stop? The bad judgment is already passed. That's where the sibling comes in, certiorari.
The undo button. Certiorari is used to quash, to cancel a decision that's already been made. So prohibition is pre-judgment, certiorari is post-judgment.
So why not just do a normal appeal? What's the difference?
This is the most critical takeaway. Certiorari is not an appeal. In an appeal, the higher court might reweigh the evidence. In certiorari, they don't look at the evidence, they look at the process.
They're looking for technical fouls.
Exactly. The notes list the grounds, lack of jurisdiction, or an error of law apparent on the face of the record.
That phrase is a mouthful. What does it mean, apparent on the face of the record?
It means the mistake has to be obvious. You shouldn't have to dig through boxes of evidence to find it. If the lower court said 2 + 2 = 5 in their legal logic, that's an error of law. Certiorari fixes that.
So if the lower judge just believed the wrong witness, that's an error of fact. Certiorari can't touch that.
Generally, no. But if the judge applied a law that was repealed 10 years ago...
then certiorari kills the judgment.
Exactly. And there's one more ground that's really interesting. Bias.
The case of Mineral Development Ltd. versus Bihar State. This one reads like a movie plot.
It really does. The state government canceled a company's mining license. Looked like a standard administrative decision. But the company owner proved the minister who signed the order had a personal political rivalry with him.
A grudge.
A serious one. The Supreme Court quashed the order, not because the decision was necessarily wrong on the merits, but because the decision maker was biased.
Justice must not only be done, but be seen to be done.
That's the principle. It humanizes the law. It recognizes that officials can be petty, and we need a check on that.
All right, we've commanded action, we've stopped bad trials, we've deleted bad judgments. The final one in the stack has the best name, Quo Warranto.
It sounds so medieval, doesn't it?
It sounds like a challenge at a castle gate. By what authority?
And that's the literal translation. What is your warrant?
Yeah.
This writ challenges a person who has taken over a public office to prove their legal right to sit in that chair.
It's like walking into a CEO's office and saying, show me your contract or get out.
If the CEO was a government official, absolutely. If they can't show legal authority, they weren't qualified, the appointment was rigged, the court ousts them immediately.
No, you usually have to be the one who's hurt to bring a case, but the notes say Quo Warranto breaks this rule.
This is the citizen's weapon. For Quo Warranto, the normal rule is relaxed. Any public-spirited citizen can file this writ.
So I don't have to be the guy who didn't get the job.
Nope. You don't have to be personally affected at all. The logic is that an imposter in a high public office hurts everyone, so any citizen can blow the whistle.
The case cited is G.D. Karkar versus Shovde.
Right. A private individual challenged the appointment of the state's advocate general. He wasn't applying for the job. He just pointed out that the appointee didn't meet the legal requirements, and the court said, you have the right to ask.
That's powerful, but there have to be guardrails, right? I can't just use this on the manager of my local grocery store.
No, absolutely not. The notes are clear. It has to be a public office created by statute or the Constitution. The case of Arendra Chandra versus Nagendra clarified that. Someone tried to use it against a committee of a private school.
And the court said?
No, that's a private body. Use a different legal tool for that. This is for public trust.
There's one more limitation here that feels really relevant today. The line between a political issue and a legal one.
The case K. Sukumaran versus Union of India.
This is where a petitioner tried to oust a chief minister, arguing he'd breached his oath of office by, being a bad CM.
I think half the population would love to use that writ at any given time.
Yeah.
You promised X, you broke your oath, get out.
Right. But the High Court shut it down. They said breaching an oath in that way is a political matter. It's not a defect in the legal title to the office.
Explain that difference.
Legal title is about the paperwork. Were you elected properly? Do you meet the age requirement? Are you a citizen? Quo Warranto checks those objective facts.
It checks the resume and the hiring process.
Exactly. It does not do the performance review. Keeping promises or upholding the spirit of the oath, those are subjective political judgments.
The court basically said, if you think the chief minister is doing a bad job, there's a remedy for that. It's called an election. The court won't step into the voting booth.
That makes sense. Otherwise, you'd have a juristocracy, not a democracy.
The writ is a legal scalpel, not a political hammer.
Okay, let's do a quick fire recap. A cheat sheet for anyone listening. Mandamus.
We command. Forces a sleeping government to do its mandatory job.
Prohibition.
Stop. Freezes a lower court trial that's going off the rails, issued during proceedings.
Certiorari.
Quash. The undo button. Wipes a bad judgment off the record after it's been made.
And Quo Warranto.
Show your warrant. Challenges an illegal appointment. The one any citizen can fire off.
So putting it all together, plus the fifth one, habeas corpus for illegal detention, what's the big picture here?
When you step back, you see an ecosystem of accountability. Mandus fixes inaction. Prohibition and certiorari fix judicial overreach. Quo Warranto fixes corrupt appointments.
Yeah.
No authority is absolute.
It turns the average citizen into a potential watchdog. That's pretty empowering.
It's the legal embodiment of checks and balances. It makes the rule of law real.
But I just can't shake this thought from the intro. There's that but.
Article 359.
Right. We've spent all this time talking about these incredible tools, but the notes say that during an emergency, the president can suspend the right to even go to court to enforce them.
It's the central paradox of constitutional law. The Constitution creates these superpowers to protect you from the state.
But it also gives the state the power to turn them off.
When it claims its own survival is at stake.
It really forces you to ask, if Article 32 is the protector, but the government can suspend the protector, how absolute are these superpowers really? Are they rights? Or are they just privileges the government lets us have until things get tough?
That is the ultimate question of civil liberty. And history shows that the answer often depends on who is holding the switch.
A provocative thought to leave you with. That's all for this deep dive into the world of writs. Hopefully you feel a little more armed against the machine. Thanks for exploring the legal weeds with us.
Always a pleasure.
We'll catch you on the next one.